happening, gang? It's your boy Retro back again with another reaction video. Yeah. Today we got another huge update. Now you guys can probably already tell that it is going down. Just by that title alone, you guys are definitely going to want to check this one out, as we got devastating news coming from that New York District Attorney Alvin Bragg and his pending Trump case, as it looks like this brand new evidence potentially lead to the dismissal of his case in its entirety, guys. And I'm excited to get into it, so we're not straight into it. All I ask that you guys please hit that like button, hit that subscribe button, and without further ado, hop straight into it, folks. Check this one out.
Well, he'll be charged with something he didn't do. We know that for a fact from Michael Cohen himself and his lawyers. But I think it's going to be a books and records kind of charge. And knowing Alvin Bragg, the Soros-backed DA, I assume that he is going to try and stack several of these misdemeanors that a normal person would never be indicted for, let alone charged with, and try and make a felony.
All right, you guys, and just yesterday we had the great Jonathan Turley with a breaking news update that he covered here in this article. It says the Second Circuit to hear Trump's appeal for the New York criminal case. Today, the United States Court of Appeals for the Second Circuit will hear the oral arguments on a threshold issue in the criminal case against President Donald Trump in New York. The case is still pending in the New York court system after his sentencing, but President Trump wants the case removed to federal court, which it should be. He is relying on last year's presidential immunity decision and arguing that the Manhattan District Attorney Alvin Bragg tripped a wire by calling a former White House aides as witnesses. And this is where we're getting this whole maybe dismissal of the case, where Alvin Bragg called. It's supposed to be on a personal level. He's trying to bring about this prosecution, but he has former White House aides that he had testifying against Donald Trump in a presidential capacity. And for you guys out there confused, I definitely know it's been a minute since I've covered the whole witch hunt by Alvin Bragg and that Judge Juan Merchan. So I'm going to give you guys a little bit of background and a refresher here with a couple clips to bring us back up to speed on this.
And let's pretend I'm at this hearing, that I'm the judge, and Mr. Bragg has to present not his case, but I want to deal with this issue of dismissal or potentially summary judgment. Mr. Bragg stands before me and I say, Mr. Bragg, I have read your 34 charges. I'm a little confused. Yes, Your Honor, what might it be? What is the crime that you're alleging? Well, Your Honor, we are alleging that the misdemeanor statutes in New York were violated with respect to the reporting of businesses, and that Donald Trump concealed a payment to Stormy Daniels in a non-disclosure arrangement, hush money, in order to violate the Federal Election Commission laws with respect to positive information in an election that's illegally paid for. Well, that's interesting, Mr. Bragg. I have a couple of questions for you, yes. Now, this misdemeanor statute you're looking at, it's already expired. The statute of limitations are over. They've been over years ago. Yes, Your Honor, but this revives it. Well, I have a question. So why did you bring the case now? It's number one, Mr. Bragg. Number two, you don't get to come into this courtroom, base a case on a federal offense that has never been charged, let alone adjudicated. It's never been charged at the federal level with the Federal Election Commission, referring it to the Department of Justice. It's never been charged by the U.S. Attorney's Office. In fact, both of those entities looked at it and took a pass. So you're asking me, a judge, to take your 34 charges to resuscitate a misdemeanor statute that lapsed years ago because now you decide to bring the case now in the middle of an election, and you claim it's resuscitated and it becomes a felony for which Mr. Trump can serve decades in prison because you have decided, a local elected DA, not the U.S. Attorney's Office, not the Department of Justice, you have decided that Donald Trump committed a federal campaign violation for which he's never been charged, let alone has the matter been adjudicated. Do I have that about right, Mr. Bragg? Yes, you do, Your Honor.
The reality of the situation is this case never should have been brought. Cy Vance passed on it. So did Alvin Bragg. But then the president decided to run for office. So that's why we are here. Judge Merchan's decision today, while it does show some deference, is still flawed, in my opinion, because of one thing. Like you said, the Supreme Court, which is the highest court in this country, a country based on the Constitution, separation of powers, we have that in place for a reason. They said that a president is immune, and that's all presidents, not just President Trump, from these types of political or any, frankly, prosecution, persecution, civilly or criminally.
All right, so I hope you guys enjoyed that little refresher, kind of jogging our memory and bringing us back up to speed on this Frankenstein witch hunt case brought about by District Attorney Alvin Bragg in the state of New York. It's been a while since we've covered it, but I seen this breaking news update coming from the great Jonathan Turley, and I could not resist. So let's hop into that. It says last year, the Supreme Court issued a historic decision in the Trump versus United States to define the scope of presidential immunity. It says that the court found that there was absolute immunity for actions that would fall within their exclusive sphere of constitutional authority, while they enjoy presumptive immunity for other official acts. They do not enjoy immunity for unofficial or private actions. The court has often adopted tier approaches in balancing the powers of the branches. For example, in his famous concurrence to the Youngstown She in Tubco versus Sawyer, 343 U.S. 579, Justice Robert Jackson broke down the line of authority between Congress and the White House into three groups, where the president is acting with express or implied authority from Congress, where Congress is silent, the Twilight Zone area, and where the president is acting in defiance of Congress. Here, the court separated cases into actions taken in core areas of executive authority, official actions taken outside of those core areas, and unofficial actions. Actions deemed personal or unofficial are not protected under this ruling. Trump is arguing that he is protected by presidential immunity and that this should be heard in a federal court, which I think it should as well. This right now is in a New York State court and definitely should be heard on a federal level. Trump is citing Bragg's callings of former White House Communication Director Hope Hicks and former Executive Assistant Madeleine Westerhout as witnesses discuss matters occurring in the White House and during Trump's first term. So essentially, the conflict that Alvin Bragg is running into here is with the presidential immunity ruling coming from the Supreme Court, where, he has to prove that Donald Trump acted criminally in a personal capacity, but he's already called former White House aides to testify, and they've already went on the stand. The jurors have heard them. Now he's coming in saying that they have to just disregard and forget everything they've heard. Trump is saying that's not how this goes. This whole thing needs to be tossed out. And I totally agree. Continuing on, it says Bragg is arguing that it's too late for such removal. Trump's prior efforts at removal have failed. The arguments will now be heard before judges Raymond J. Lawyer, Susan L. Carney, and Myrna Perez. This is a difficult case to make at this stage of the case. If Trump loses, the criminal case will continue through the state system and may even eventually find its way to the Supreme Court, which it definitely should, and it's going to get overturned. I have long been a critic of the case, and there are strong grounds to appeal. Definitely going to see if this does come down with Donald Trump getting the hammer. We're going to see this caught up in the appellate division for quite some time. I wouldn't be surprised to see this whole thing getting overturned. It was a flimsy ham baloney case. Shouldn't have been brought about in the first place. It was dead floating in the water. Alvin Bragg, we can't forget, he declined. We've already had multiple prosecutors turning down this case. Even Alvin Bragg turned it down. Wasn't going to bring it at first. And then the timing of this case was quite suspicious when he brought it about against Donald Trump. It was very convenient when he had turned it down previously, Frankenstein case, and resurrected even to come after Donald Trump, even upgraded misdemeanors up to felony so that he could nab Trump. It is just insane. For example, though, Judge Juan Merchan effectively guaranteed a conviction by telling jurors that they did not have to agree with specificity on what occurred in the case to convict Donald Trump. The only way to get beyond the passage of the statute of limitation, the dead misdemeanor for falsifying business records, had been to allege the bookkeeping violation in question occurred to conceal another crime. Bragg did not bother to state clearly what this crime was, originally alluding to 4 different crimes. It was not until the end of this case that Judge Merchan will lay out 3 possible crimes for the jury, all the way up to the final instruction in the case. Legal analysts on CNN and other outlets expressed doubt about what the actual theory of criminal conduct was in this case. Despite spending little time on these secondary crimes at trial, Merchan told the jury they would convict if they believed that invoices and other documents had been falsified to hide federal election violations. violations, other falsification violations, or a tax violation. Those are very different theories of a criminal conspiracy. Under one theory, Trump was hiding an affair with an adult actress with the payment of hush money before the election. Under another theory, he was trying to reduce a tax burden for someone else. That part was left hazy. As a third alternative, he might have falsified the documents to hide falsification of other documents, a perfectly spellbinding circular theory. All right, so basically what that's saying is Judge Juan Merchan gave specific instructions to the jury saying that this did not have to be proven beyond reasonable doubt. If they even had suspicion, they could go ahead and say that Donald Trump was guilty. If those sound like they could be three different cases, then you are right. Yet Judge Juan Merchan told the jurors that they did not have to agree on which fact pattern or conspiracy had occurred. They could split 4 of the 12 jurors on the secondary crime, motivating the misdemeanors, and just declare that some secondary crime was involved. Wow. Many of us are eager to see the New York system move on this case, as well as the equally grotesque case brought about by the New York Attorney General Letitia James. The cases, however, continue to move forward at a glacial pace in the notoriously slow New York legal system. Okay. Oh my goodness, guys. There we have. We're seeing that whole Frankenstein witch hunt case brought about by District Attorney Alvin Bragg over in the state of New York, falling apart and busting open at the seams, which we all knew this was going to come. When he first brought about this case, everyone was just outraged. We were upset because we could see it was a blatant witch hunt. There were so many factors that should have had this case tossed out a long time ago. We can't forget that Judge Juan Merchan should have recused himself from the beginning. We found out that his daughter was like a major Democratic donor, shoveling money hand over fist out to the Democratic Party, but yet he stayed on this case. And then he allowed his court to turn into a full circuit show by Alvin Bragg bringing about this flimsy case, no crime, no actual crime committed or listed, saying such hush money payment paid over to Michael Cohen to give to Stormy Daniels. It didn't make much sense. And then we have to note the fact that most of these charges had passed the statute of limitation. The time had elapsed to bring about this case. Alvin Bragg and many other prosecutors had passed up on bringing this case all the way up until Donald Trump said he was going to run for presidency again. And in 2024, then he brought about this case revived. It was dead floating in the water. Alvin Bragg said, I'm going to bring it back to life. We're going to upgrade these misdemeanors up to felony charges so that we could really get something to stick on Donald Trump. This whole thing was egregious from the start. And with that, you guys, I'll definitely be covering any more updates that come on this case now that we're starting to get more motion, more traction on this one. Hopefully we'll see this thing either overturned in the appellate division or even dismissed entirely, guys. But definitely hop in that comment section. Let me know your thoughts. Comments are open. I'm excited to hear what you guys are thinking. Also, make sure you guys please hit that like button, hit that subscribe button. If you'd enjoy more content like this, catch you guys on the next one.